So, as part of our mostly monthly, not every month, but most months, we do this presentation we call the Smart Board, where we go over pending new issues, hot topics, whatever it seems that the community association community is looking for. So, as I said, this one is going to be the 2025 legislative update for community associations. Uh, Michelle, if you could go ahead and hit the next slide. Most of these laws, by the way, were effective July 1, 2025. So going back now almost 2 months, but some of them do have some later deadlines, but most of them are effective that date a couple months ago. So at a glance, what are we going to go over? The biggest bill is HB 913, which is condominiums and cooperatives. There is nothing about homeowners associations in that bill. I don't know why the legislature decided to leave the homeowners associations for the most part alone this year, but they did. It's condominiums and cooperatives that got the update, not the homeowners associations. So any provisions in 913, if you're a volunteer for a homeowners association, these do not apply to you. That being said, the legislature does tend to the extent they update one part of the legislation for one group, either co-ops, condos, or HOAs, be watching this space for next year. They may update the other community associations accordingly. So it certainly doesn't hurt to be aware of what your brother and sister communities are doing. We're also going to discuss HB 897, which is timeshare plan management. There's probably no one on here that is interested in the timeshares, but that is part of the education requirement that the DBPR approved for us, for managers to get the credit for this course. So we are going to briefly go over that. SB 108 is some administrative procedures we're also going to discuss. SB 472, education and correctional facilities for CAMs. Hold that thought. That's an interesting one. And then finally, we'll go over SB 948, which is flood disclosure. So that's what we're going to be going over today. And I should add that HB 913 has a lot of changes. Some of them appear to be really non-consequential. Others appear to be really not sure where the legislature was going. So we're not going over line by line 913 today. We are hitting the highlights and what's required for the education. So Michelle, next slide, please. Okay. So starting with what was done for the milestone inspections. Now, as a reminder, the milestones and what people call the SIRS or SEERS, the Structural Integrity Reserve Studies, are still for the condominiums that are 3 stories or higher in habitable structures. So if you're a 1-story condominium, this still does not continue, this still does not apply to you. But these are updates for those who do have these milestone and SIRS requirements. Just as a reminder, a milestone inspection is a structural inspection that's required when a condominium building reaches in a window of 25 to 30 years. That's determined by the local enforcement agencies, and then every 10 years thereafter. So it is a structural inspection. It's not the same thing as the Structural Integrity Reserve Study, which I'm going to discuss next. But these are the updates for the milestone inspections. And that is that local enforcement agencies now must report the milestone inspections compliance data to the DBPR. So in addition to the reporting requirements that were already there are now more reporting requirements. There is obviously an effort from the state here to try to nail down and figure out that every condominium has complied. That seems to be the intent here. The next one, independence. What does that mean? Architects or engineers who bid to perform a milestone inspection must disclose in writing to the association any intent to bid services related to any maintenance, repair, or replacement which may be recommended by the milestone. So that has to be disclosed for the milestone studies. If the professionals performing the study are going to also bid for the work, they have to disclose that. What else do they have to disclose? Any design professional or contractor who submits a bid to the association for performing any services recommended by a milestone inspection is prohibited from having any direct or indirect interest in the firm that provided the milestone inspection or from being a relative in the firm unless that relationship is disclosed to the association in writing. So again, if there's going to be any sort of financial interest that the entity performing the milestone inspection may have in the work that's going to be performed, it must be disclosed. And if it's not disclosed, the contract is actually voidable by the association. So this is something that boards should be aware of. Many of you have maybe already done your milestone, don't have one pending, but this is some protection for community associations for any potential self-interest that might not be evident on its face. These design professionals are now required to disclose it. So next slide, please, Michelle. Okay, so this slide addresses the structural integrity reserve study updates. Again, the SIRS or SEERS, depending on people's pronunciation of choice. And as a reminder, that study is a newly required study by the Condominium Act that was a result of the unfortunate tragic collapse of the building down in South Florida in Surfside. That has to have been already done, hopefully by most associations under the previous statutory deadlines. But if not, I'm getting ready to explain there has been a little extension of the deadline, and then every 10 years thereafter. So as you can see at the top of the slide here, the legislature this year did extend the deadline to December 31st, 2025 from what was December 31st, 2024. These are for buildings that not developer controlled. There's some different provisions on that. We're not discussing that. We're talking about associations that are controlled now by owners, um, and that were existing before July 1, 2022. So if for any reason you have an association that didn't make the deadline, it got extended. Not a surprise considering that it was a lot to put on associations in a very quick time frame, and that it wasn't easy for a lot of associations to get the professionals needed to do the study. There is also now expanded reserve funding flexibility. So to the extent an association is looking at a need for some serious cash to fund the new SEERS requirements, also called the items listed in paragraph G, for the structural parts of your reserves, the statute now allows that special assessment, lines of credit, or loans can be used to fund those amounts as opposed to putting them in your regular reserves amount, though with the caveat that you have to have approval of the majority of the voting interests. So be aware that those are new statutory options that may or may not have been something you were looking into before for your associations or as a board volunteer, but these are now statutory options.
And I'd add a quick comment about that too.
Go for it, Jim.
So again, in any situation where an association is thinking about investing anything, of course, we advise you to consult with your accountant as well as your general counsel to determine whether that's really appropriate for you. Just because you can invest doesn't necessarily mean you should. And of course, there are some restrictions as far as what those vehicles have to look like and how that has to be regulated. So just because you can invest your reserves and some other options we'll be talking about today doesn't necessarily mean you should. Again, member approval is required to prevent you from necessarily running over with that. But just an interesting note, consult your other professionals and make sure you're getting the proper advising on how those investments work.
Yeah, Jim's absolutely right. The reason these laws were started was because of what the legislature heard and saw with Surfside, which was unfortunately some insufficient funding for building needs. So this is not meant to be a getaway out of that, but in a world where costs are rising all the time, it could be a way to assist so you don't sticker shock your owners. But again, consult with your counsel for your particular association. So now the legislature also clarified pooling. Again, these are for the SERS reserve fundings, the structural items in paragraph G that are different from your general reserve funding. These are specifically your SERS funding. The legislature clarified that reserve funding for SERS may be pooled, but only with other SERS reserves. So for instance, if you have everybody's going to have, if SERS applies to you, if you're 3 or more habitable stories, everyone's going to have a reserve fund for the roof. You may also have a reserve fund for windows under paragraph G. Those two can now be pooled, but they can only be pooled together. You can't pool them with your other reserves, such as what might be a reserve for the paving your parking lot, which is not a structural issue. And the legislature added a vote of the members is not required for the board to change the accounting method for the SERS reserves to a pooling accounting method or a straight line. So if you want to go one way or the other as a board of directors with your SERS reserves, the statute has given you that specific option. And then they also added in the new legislation that at a minimum, the SERS must include a funding schedule based on a baseline funding plan that provides a reserve funding goal in which the reserve funding for each year is sufficient to keep the cash balance above zero. Now, I can only speculate as to where this came from, but I have to believe the legislature felt that some of the SIRS reports really weren't as detailed and as instructive as they needed to be in terms of where exactly the funding was, where the baseline was, and where the zero line was. So this is now a specific requirement. If you do feel like you have a SIRS report that maybe didn't make these issues clear going forward, this is something the statute now requires. So I'm going to turn it over now for the next slide to Attorney Jennifer Hicks, unless I should caveat, Jim or Jennifer, if there was something in the chat or something you felt like related to these concerns that we should discuss before moving forward.
There are certainly popping up a lot of questions in the chat. I see a question about if an engineer is performing the milestone, will then be overseeing, I'm assuming they mean the repair project, but not actually doing any physical work on it. Does that need to be disclosed up front before they bid on the milestone inspection work? 913 is a little unclear about that. On one hand, it says the engineer, if they have an intent to bid on any services related to maintenance, repair, or replacement, that must be disclosed. Later on in the statute, it says any design professional who submits a bid to the association for performing any services recommended by the milestone inspection may not have an interest. So it's unclear. I would suggest that, it's sort of going to be up to the engineer. I would suggest the engineer should disclose any intent to be a project manager or supervisor. But, that's an answer we may not have with certainty until it's actually challenged in court. Let's see here. Does a line of credit need to be approved by a majority of voting interest or just a loan? The way the statute is phrased, taking out a line of credit would also need to be approved. Any switch in funding methods for your reserves would need to be approved by a vote of the majority of the voting interests. Anybody else see anything real quick? I'm just reading through.
I'm scrolling as well, but those are some very good questions. Thank you for pointing those out, Jim.
10 years, a SIRS needs to be conducted every 10 years at least. There may be other circumstances where and it's from the date of the last SIRS. And there may be circumstances where they need to be conducted sooner than that. For example, if your association converted a common element to a limited common element and that impacts your SIRS, yes, you would want to revise SIRS report to reflect that. And that's actually new in the statute as well, which says your SIRS can be revised to reflect changes in the property.
Yes, definitely. That's also a very good question. There are a number of associations who have taken windows out of the association's responsibility because of the funding issues for SIRS that presents. So yes, you would definitely want to get a revised SIRS after a change like that. And also after you re-roof your buildings. Other significant changes. It's getting a revised, but that's not the same thing as the statutory requirement that you get a new one every 10 years. Revised one is something that can be very useful for your reserve funding and how you're going to go forward with it.
And I think that answers most of the questions up to this point that we can talk about quickly.
I'm going to just add one real quick. There was a question, any specific rule regarding how to divide the existing, let's just call them the traditional statutory reserves and the SIRS. There is no rule per se, but it has been pretty much industry standard conclusion that you should have them at a minimum line item, indicated, and ideally in two different accounts. But there is no specific rule. It really is up to the association how they best want to make sure that they don't accidentally use traditional reserves for a SIRS reserve item or vice versa. Okay, well, Jennifer, do you want to now take over the next slide?
Thank you. So I saw in the chat, someone asked us to let you know when we move from only 3 stories and above to all condos. We are now there. We're moving away from the limited to 3 stories and above to all condos.
Yeah, all condos
now.
can listen now.
Yep, welcome back. Hope you have your coffee. So as we said earlier, HB 913 does have a lot in it that doesn't necessarily involve what everyone who is here today. One of those things is they made it possible for multi-condominium associations to use approved alternate funding methods for their reserves. Now those have to be approved by the division, which they may reasonably be expected to fully satisfy the association's reserves obligations. So again, unless you are a multi-condominium, that's not really going to affect you. you can now, the statute has clarified that the board does have an explicit duty to use its best efforts when investing your reserves or your funds, obviously. This includes the responsibility to consider risk and return in an effort to maximize those returns. Now, the statute gives you the authority, but you need to check your bylaws. This is not something that you can look at in a vacuum. You need to see what restrictions your bylaws have as to where and who you can invest with. We do see some that are silent. We do see some that are very restrictive. On general basis, our recommendation is to make sure it's FDIC insured. That's really going to be the best way to ensure that you're going to be as protected as you can. And then we recommend, remember, it's not your money. It's the association's funds, reserves for a reason. Pay attention to them. Just because you can invest, it doesn't always mean you should. And then 913 goes on to our favorite or most complicated answers and questions is video conferencing. They've defined the video conferencing and required notice and recording requirements. Let's get into that a little bit more detailed. Michelle, next slide, please. So we don't have a lot of the sections up, but because the bill is not yet implemented into the online statute, I've put the video conferencing section here. They've defined video conferencing as real-time audio and video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. So we're not talking conference calls. We're talking Zoom, Teams, and all these other video/phone enabled abilities. Now, if you're using this, they go further to say, notice for any meeting that will be conducted by video conference must have a hyperlink and a call-in conference number, and it must have a physical location where those unit owners can attend the meeting in person. So even if you are meeting by Zoom or whichever platform you require or you prefer, you still have to have a physical location where those owners can attend in person. And then all meetings are conducted by video conferencing must be recorded, and that recording is considered an official record and must be kept for at least 12 months. Now, even if you are doing a video conferencing and you know you have to have a physical location, that could be your manager's office, even if no one shows up, you still have to have a physical location. And that physical location has to be within 15 miles or within the same county as the association. So they put a little bit more restriction on where you can have your physical meeting when you're having a Zoom conference. So the statute is not clear, as we've said a few times today. They did not really go into the detail of what about meetings that are closed. We've been asked a few times about this already, and what we're basically saying is until it's clarified by either next year's statutes or a court, best is to be the most conservative and go ahead and record those closed meetings, and they just simply go into the file of closed and not owner accessible, at least for the time being. Okay, sorry, making sure I covered all the key points on that one, because that is obviously one of the big topics this year. Before I go further, do we have any questions regarding the meeting? I was not looking at chat.
Yeah, there's a question here that I'm trying to, the question is, for recorded meetings, does that include committee meetings as well? And
it does say any meeting, so I would say yes. Sorry,
yeah,
Jim.
I agree. It says all meetings conducted by video conference. So yeah, I would suggest that even if committee meetings are being conducted by video conference, they should be recorded and maintained as an official record. It'll be interesting to see how that interplays and if that's going to be something that in the future can be adjusted by governing document. But for now, the broadest and safest interpretation would be, yeah.
Yeah.
There was also a comment earlier in the presentation where someone was saying this is going to create some storage issues for associations. And that is something that if you do want to be thinking about consulting with your manager or whoever they would recommend for IT on that. because that is going to create some storage issues, particularly if you have pretty frequent meetings or you're a large community.
And it's my understanding that's why the video recordings only need to be retained for 12 months from the date of the meeting, because it is a storage obligation and it's not as simple as storing documents. So it's not a 7-year retention like you would face with, say, your meeting minutes or something like that. Um, and this is a question we sort of anticipated, can a board have a closed meeting without all owners? Yes, boards can still have closed meetings. And remember, when we're talking about this video recording thing, again, this is in particular to condominiums. This is not an HOA requirement. If a condominium is having a closed meeting with its attorney or to discuss personnel issues, which are the two cutouts for closed meetings under the statute, as written, our advice is that those meetings should still be recorded, but not made available to the owners in response to a records request. The statute says all meetings involving the association and video conferencing must be recorded. I have been told by somebody involved in the legislature that this is a known glitch and that they will be fixing this language probably to cut that out. But for now, yes, the best and safest advice would be to have those recordings, even though they'll likely never be seen by anyone else ever again.
The other niche for the Zoom meeting is if you are having your annual meeting, a quorum of your board must be present in person. So you can't have all your board members on Zoom for your annual meeting.
Oh,
Now,
which is a big problem for the associations that are mainly rentals.
yes,
We're definitely getting some negative reactions to that requirement. And honestly, we're not sure why the legislature thought that was a wonderful idea. In a world where a lot of people are now using video conferencing to attend a meeting, requiring board members to be there in person seems pretty burdensome, again, if it's not a community where people are living there at least seasonally.
I'm going to try to rapid fire some of these last few questions that came in here. A meeting with maintenance with a quorum of the board present. Yes, if you have a quorum of the board, you have yourself a meeting, unless it's, again, there's a cutout for closed meetings for personnel decisions. Again, it would still have to be recorded, but personnel decisions based on the way you form that question, probably not what we're talking about here. Personnel decisions usually like hiring or firing on-site staff. It doesn't involve hiring or firing a CAM. That's not a personnel decision. But if the association directly employs a maintenance person and you're talking about hiring or firing them, giving them a raise, things like that, those can be conducted via closed meeting. Anything else, if you're directing the maintenance staff to do work, then yes, that would be with a quorum of the board. That would be a meeting that would need to be open, recorded, and subject to all of these. Yes, video conference has a very specific definition, so we can confirm that a conference call that does not have a video component available would be exempt from this recording requirement. In fact, I think it would, if you try to record a phone call only and you do not get the consent of every person in participation, you may be violating Florida's wiretap law. If a committee consists of out-of-town members, how can they accommodate the physical presence in the county? So the committee members can all appear virtually. There just has to be a physical location present in the county for members who wish to attend that meeting. So I'm not sure if that was unclear or that question was asked. The only time the members of the board need to be present physically at a meeting is for your annual meeting, where your annual meeting, at least a quorum of the board needs to be present now if you're using a video conference option. So if your community intends to do a video annual meeting, you need to have your directors planning their vacations accordingly. At least the majority of the board, or whatever a quorum is for your association, would need to be present at that meeting.
And Jim, related to that, somebody did ask, do we have to use video conferencing? And the answer is no, you don't have to.
If no board or staff is present at the physical location, do we have to provide tech resources for anyone who decides to sit in the empty room? Yes. The physical location is there for people to attend the meeting that is being conducted via video conference. So whether it's a director, the CAM, or just another responsible owner, somebody needs to be present at the physical location with a laptop and a camera and a microphone so that those people who attend in person can participate in the meeting. That's a question that sort of goes back. Have you guys seen anything else? I'm trying to read while talking. And
Yeah. We can maybe even further discuss this topic once we go through the slides. Seems like there are a lot of questions, so.
yeah.
and I'll, yeah.
Okay. So So next we're going to move on to electronic voting with the update in, oh, no, one back, please, Michelle. So on the update that they put this year in the HB 913, it has essentially made electronic voting mandatory. So it used to be if the board did the proposal and you've got usually a vendor to help with your electronic voting. Now, if at least 25% of the total voting interest petition for such a program, the association must adopt electronic voting for the next election. Now, the board has to hold a meeting within 21 days after receipt of the petition, and the board must receive the petition from essentially the ownership within 180 days after the date of the last scheduled annual meeting. So this is more your formal policies, your formal using a vendor. Now, what if you have already adopted e-voting? Sorry, if you have already adopted e-voting, this portion does not apply to you. But if you have not adopted e-voting and without a petition or a special request from the membership, the board must do the following things. And this is where we come into the essentially mandatory issues. So your board must designate an email address for receipt of e-ballots. An owner is entitled to send an e-ballot to that email address without complying with any ballot secrecy provisions. So what this is basically saying is as long as the owner puts specific language saying that, they understand that they're emailing from their own email and they're not going to have a secret ballot, the association must accept their ballots. Now, the association must count the completed e-ballots received through this method, provided the ballots comply, like I said, with the specific formatting and content requirements. Compliant ballots must be sent to the association's email no later than the date and time at which the matter is being voted on is set to start. So if you have a 6 p.m. meeting, the understanding, at least in the wording of the statute, is whoever is responsible for checking that email address will be checking it up until 6 p.m. So if it's your manager or a board member, you leave your house, say at 5:30 to go to the meeting, nope, you still have to check it up until the 6 o'clock time. We understand that's going to become an issue depending on how your meetings are set up, but that is how the current statute is written. Now, there is now a rebuttable presumption that all emails, folders associated with that email account are going to be checked. So you're checking your junk mail, your spam, your inbox, anywhere and everywhere that this email can end up, you're checking it at latest the time of the meeting. There is no requirement that the association generates or provides the ballots. It appears to be, at least from the current language, that it is the owner's responsibility to check the statute and see what they are required to do to have such a ballot. So we are going to be moving more into an electronic age, and this is just more evidence of that from our government or state. Next slide, please. So this is, again, I believe this is Jim's slide, but correct me if I'm wrong.
Nope, we're getting into House Bill 897, unless you want to start talking about some super fun stuff. And in fact, we're going to start talking about timeshares now. So for those of you who are not CAMs, you individual directors, this is the part of the presentation where I'm going to start talking about laws outside of 718 and 720 so that the CAMs who are participating here today can get their credit for their continuing education classes. We will come back to 913, time permitting, at the end of the presentation to talk more about some of these very good questions you're raising in the chats. But for you CAMs, pipe up because here's some interesting licensing information for you. House Bill 897 talks about CAMs who also operate under timeshares, if you manage timeshares. And timeshares are, of course, governed by Chapter 721. We don't deal with them very often in our classes, but the division has required we talk to you about this particular bill since it does impact your license. So for those of you who are licensed CAMs and you've taken over and you're working for or managing a timeshare, you need to know that 468.4335, the part of the CAM licensing statute that deals with conflicts of interests, is not going to be your requirement when you're working for a timeshare. Chapter 721 has its own conflicts of interest provisions for its managers. So if you are a licensed CAM and you are operating or managing a timeshare, you have to comply with 721.1313C1 when it comes to conflicts of interest. 721 has a much more intrusive and in-depth conflict of interest reporting mechanism. It requires annual disclosures. You have to do an annual mailing disclosing all of the conflicts of interest to every member. It has to be noted on every contract in which the conflict of interest is present. All of that good stuff. It's far more complicated. But only if you're involved in timeshares. And if you're managing a timeshare, you should be certainly more familiar with 721 than probably I am, quite frankly. Timeshare management firms and their CAMs, like I said, are governed under 721.13. So if you're a CAM and you're managing a timeshare, you may have dual obligations. When in conflict, generally 721 is going to prevail over your 468 requirements. Not to say you don't still have all these obligations. For example, 721 under House Bill 897 added in very similar language that we see in 468, which is that timeshare CAMs and firms have to discharge their duties in good faith. Directors and CAMs are going to have limited liability for things as long as they discharge their duties in good faith. They're not going to be responsible for conflicts of interest as long as they make the 721 disclosures. So again, 721 is its own beast. If you're getting involved in timeshares, certainly familiarize yourself with that and know that you have these perhaps dual or even sometimes conflicting requirements. The Board of Administration for a timeshare condominium, please ignore, I mean, for anybody in here who's not a CAM, ignore the word condominium in there and put your heads back down. For you CAMs, a Board of Administration for a timeshare condominium must meet at least once a year now. They're allowed to have more meetings than that, but there is at least a once per year requirement. That is not regular condominiums. 718 folk, ignore that. You have different obligations. That is just for timeshare condos. And of course, one other thing I want to talk about, which actually it's at the last line there, which is enhanced CAM firm licensure and regulation requirements. That's actually a part of 913 that I just cut out because we're talking about CAM licensing. This is a change to Chapter 468 that says if a CAM or CAM firm has their license revoked, that CAM can have absolutely nothing to do with the CAM business for at least 10 years. If your license is revoked, you cannot be a CAM, you cannot apply for a CAM license, you cannot work for a CAM, you cannot own a CAM. You ostensibly could maybe be a janitor for a CAM, but that's about the extent of what you can do. If your license is revoked, you're out, 10 years minimum. Statute doesn't even say that, hey, at year 11, you can come back in and we'll be happy with you. It just says for a 10-year minimum, you can't even apply for a license. Also, 468 has been amended to say that every CAM and CAM firm must have an account, like a profile registered with the division that's going to list their on-site CAM, like what associations they work for and things like that. I'm not sure. The statute is unclear whether that is the same as your licensing profile page through the DBPR or if this is supposed to be something different. I don't know. And as we'll talk about shortly, there's been a lot of conflict between the legislature saying the DBPR has to enact certain restrictions and websites and stuff like that, and the DBPR actually being able to do it. So I'm not sure if that's the same thing here, but there is a requirement that became effective July 1st that says every CAM and CAM firm must have some sort of account with the division that lists all this information. It may be your regular licensing portal. I don't know. Next slide. Basically, there's been a big crackdown on CAM accountability this year. So the division is going to keep track of who you're working for, what associations you're involved with, and they're going to use all that information to notify those associations in the event your license is suspended and or revoked. So again, these are all going to be very important things down the road. The next bill I'm going to talk about is Senate Bill 108. And this is probably going to be pretty dry even for the CAMs. This is about how Florida agencies make rules. So the DBPR, Division of Condominium, the department and the division, both agencies, they have rulemaking authority. For CAMs, you know that the Florida Administrative Code has a lot of stuff beyond what just the statutes say concerning how you operate your license, how 718s, condominiums, and HOAs are operated. Senate Bill 108 is talking about how those rules are made. So the newest change is that any agency, such as the Division of Condominiums, must review all of its existing rules that were in place as of July 1st of this year by July 1st of 2030. They have to go back, look at every rule that applies to the division, and basically determine, you have to do a review of it. Is this still a functional rule? Do we need to amend this rule? Do we need to delete this rule? It's going to be a comprehensive review. Any new rule that they enact has to be reviewed every 5th year. While the statute says the goal of this is to increase public transparency, I think the real effect of this is going to be that we get rid of a lot of dead rules. There are out-of-date rules. There are rules that may not apply in certain circumstances. And this is going to cause the Florida Administrative Code to update itself much more frequently, which should hopefully make our lives easier going forward. Whether that's true or not, I don't know. But hey, more bureaucracy never hurt anybody, right? Coupled in 108, we also see that agencies must now file a notice of rule development within 30 days after a law says a rule needs to be made. So this is what I was talking about before. We've had these circumstances, such as in House Bill 913, that says, you know, by October of this year, you know, the Division of Condominiums is going to have this website that's going to do this, 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 and that. Well, it seems that the legislature makes that type of law and doesn't always coordinate with the division or the Department of Professional Responsibility when they're doing that. So the aim of this change is now to say that as soon as the legislature says, hey, agency, Division of Condominiums, you need to do this, you need to make this rule, you need to do whatever we're telling you, the agency, the division, is going to have 30 days from the date of that law to publish a proposal that says, all right, we understand you're telling us we have to do something, here's how we plan to do it. Within 7 days after that, they have to file a notice of the proposed rule, which means, or they have to wait 7 days at least. Then they can file a notice of a proposed rule sometime within 180 days. That is their version of the rule that they intend to use to do what the law says. So, you have to make a website. Within 30 days, they say, all right, we understand we have to make a new rule, we're going to do it. Sometime within 180 days after that, they say, all right, here's what our rule looks like. It says we're going to have this website. It's going to require every CAM to put this piece of information in there. It's going to say this, this, and that. And that'll be published. And this is more about transparency. This will give the public a chance to see these proposed rules. The legislature will be able to comment on them. The public will be able to comment on them. And, you know, more cooks in the kitchen. Whether it'll be a better recipe or more confusion, who knows? But, you know, for those who are interested, it will be more public. For rules that were proposed after July 1st of this year, and this is going to be the most useless thing I tell you all day. If everybody in this room wants to plug their ears and hum for like 10 seconds, it wouldn't affect any of you. But if an agency is going to propose a rule, they cannot incorporate other statutes and rules by reference. They have to incorporate the entire rule or put a link to the rule. The division really wanted me to tell you that, so I'm telling you that. Now you can forget it. When proposing a new rule, an agency has to expand its statement of estimated regulatory costs. These are called SERCs. Whenever an agency is posting a new bill or they're enacting a new rule, they have to basically break down how that's going to financially impact the agency or the state, what the budget's going to look like, how much it's going to cost. That's the SERC. Now that also has to include transactional cost and market impacts. Again, unless you're working for the division, that's probably not going to have any meaningful impact on your life. But again, now the public should have a greater understanding of how much some of these rules and regulations are going to end up costing as far as taxpayer money. No rule may self-sunset. This is interesting. So the agency, again, let's assume we're talking about the Division of Condominiums, couldn't enact a rule that's only temporary. They can't say, for the next 5 years, all CAMs have to do this. And as of, you know, July 1st, 2030, this will no longer be in effect and this rule will go away. Can't do that unless the legislature tells them they can do that. Any rule that's being enacted by a committee now ostensibly has to be perpetual in nature unless they're given permission to have it self-terminate. An agency must withdraw any rule that is not approved within one regular submission cycle. Basically, if they're told to make a rule, they can't get it done within one cycle, they have to withdraw it, try again the next cycle. Each agency also must publish licensing data annually in their regulatory plan. For UCAMs and the division, what that means is now every year, the Division of Condominiums, Division of Condominiums timeshares will be publishing licensing data. How many CAM applications came in, how many CAM applications were approved, how many new CAM licenses were issued, how many CAM licenses, credits were received, things like that. Any information pertaining to licensing data will have to be published annually now by any Florida agency that publishes such things. Take a quick break. I can't imagine anybody has any questions having to do with any of this.
Haven't seen any in the chat regarding any of this. No, Jim.
Excellent. Well, look at this, Cams. You're getting your credit taken care of without having to worry about really learning this stuff. So we can go on to the next slide. This is perhaps my favorite law. And again, this was specifically required by the division to be included in this class. Senate Bill 472, as Sandy mentioned at the top of the class, is titled Education and Correctional Facilities. Um, the state has decided that the Department of Corrections, again, another state agency like the Division of Condominiums, must implement a plan so that inmates completing approved classes can get credit toward their DBPR licensure, coordinating with the relevant boards to make that happen. So if for some reason a CAM finds themselves in jail and it's not related to, and they haven't lost their license in that process, they can continue to take their continuing education classes and they can still get credit for that. Basically, the goal here is to say that, even inmates are entitled to keep their licenses alive, assuming their license hasn't been terminated as a result of their conviction or arrest. So, hey, for you CAMs who are committing outside felonies or something, I suppose, congratulations, you can keep your license. But it's a fun new bill. Next slide. Senate Bill 948, this is sort of going to apply to anybody who is a landlord, owns real property, and the way it ties into this class really is going to be that it has certain requirements for condominium developers. This is about flood disclosures. So as of July 1st of this year, I'm sorry, as of October 10th of this year, this is the only law we're talking about today that isn't already effective. Senate Bill 948 doesn't become effective until October 10th of 2025. But as of October 10th, any landlord who is renting real property to somebody for a lease of 1 year or longer has to include a flood disclosure with that lease. It's going to disclose flooding risks, how many floods have happened in the past, what sort of insurance is available, that sort of stuff. There's a form in Chapter 83 that dictates what the disclosure has to be. It has to be presented separately from the lease, and this is to inform tenants of the risk of flooding as they're taking on, possession of a new property. If the landlord fails to issue that flood disclosure, and if a flood occurs that damages property belonging to the tenant can then elect to terminate the lease from the date of the flood. They have some technical requirements to how to do that. They have to send a written notice to the landlord that, hey, you didn't send the flood disclosure, I was damaged in a flood, I'm terminating the lease within 30 days, and then they have to actually vacate the property within 30 days, all 30 days of the loss. And if the landlord has any advance rent, if you had a deposit, if you paid first and last or something like that, they have to return any of that advance rent once that notice in vacating has been completed. For condominium and cooperative developers, there's a slight change to their flood disclosure form. They already had a flood disclosure form if they were going to lease any property for 5 years or more. So a condominium or cooperative that is selling or leasing a unit for 5 years and longer has to include a new flood disclosure as well. It's like I said, it was an existing form. It's just been slightly modified to discuss insurance issues a little bit more. For residential sellers, anybody who owns a home or is just selling title, ostensibly even potentially a condominium, anybody who's selling property must include a flood disclosure as well. Again, already required. They've added one paragraph to it that will become effective as of October 10th. And that's just, again, more about awareness and flood insurance that's available in the area. It's going to be no different than your lead paint disclosure or something like that when you're selling your house. And again, I mentioned this only becomes effective October 10th. And I think that wraps up all of the extraneous stuff. So now we're going to be free to talk about 913 a little bit longer. Looks like we have a few minutes left, maybe. You guys.
Yeah, we have been getting some questions that Jennifer's been answering about this electronic ballot email option. I don't know, Jennifer, if you want to discuss any of those. I see you've been answering them.
Yeah, so basically, unfortunately, while the statute did give us or give owners the right to email ballots, and they gave us a couple of things that the owners have to put in their ballots, they said we have to, associations must designate an email. It does not specifically say it has to be a new email, it doesn't have to be a separate email. But if you think about the requirement that you are checking every single folder of said email up until the time of the meeting starting, it may be best practices to have a separate email for ballots. They are technically association records. There are a lot of things that may not have been considered when this statute was written this year. We're hoping some of it gets cleaned up next year, and these are some of those issues that we were talking about. I
There was a
think that
question
was
about whether this course was required. No, this course is not required. We do have credit for managers for the course because the DBPR did give us that credit. We do not, unfortunately, have credit for volunteer board directors for the course because the DBPR has not yet given us that credit. So watch this space, though. We do anticipate having courses that we're going to have available for board volunteers to be able to get credit. This is just unfortunately not one of them.
There is, back to just questions I'm seeing in the chat, there is no requirement to print the ballot involved in this e-voting issue. In fact, there are very few requirements at all. It's my personal commentary that this is going to be one of the laws that creates more problems than it solves until it's fixed.
Hmm.
It basically says a unit owner has to identify themselves, has to identify their unit, and has to waive secrecy, ballot secrecy, and then somehow, without any specific definition, indicate how they intend to vote. So we really don't know how that's going to work. I'm not, honestly, I think the best response to this new law is that associations should really consider enacting a formal e-voting policy, contact a vendor like a quorum or somebody like that, and actually enact e-voting through the whole statute resolution and go through the whole process. And that will do away with the need to have this whole separate email address thing, and will really make your lives easier because a lot of those vendors will just solve a lot of your headaches. They'll take care of a lot of the notices, they'll count the ballots, they'll do all that fun stuff, and really makes the director and the CAM's lives easier.
Thank you for that, Jim. I was answering a question in the chat. Either of you want to bring up other questions you're seeing?
Condo associations can still vote on a yearly basis to reduce their level of financial accounting. I see somebody asked sort of a related question to that up there. On a year-by-year basis, that statute is still in effect from the last change. Depending on what level of financial reporting an association is required to have, they may still vote to reduce it with a member vote. They changed the wording of that statute a little bit, but not in a way that makes a meaningful impact to anybody here, really. Let's see here. And it looks like most other things have been answered that I'm seeing. And we're coming up on 11:53 anyway, so I'm not sure if we want to keep talking. I can do a whole hour on 913. So if anybody has additional questions, obviously our email addresses are up on the screen right now. We can answer generalized questions for those of you who may have them following the presentation. Recommendations for electronic voting vendors. Host, HOAST, as recommended in the chat, is one of the bigger vendors. We don't necessarily endorse anybody. I tend to recommend Get Quorum, as I've worked with them quite frequently. Can a board member do physical labor on common grounds? I would advise you to check with your association's insurance carrier to see how they think you should answer that question.
Somebody asked us what we think is coming next. I have to say that there was a time period where the legislature used to work with, there's a group of lawyers, committee under the Florida Bar, who are community association lawyers, such as we are. and there used to be some coordination. It seems like for the last 3 or 4 years, it's really been not a lot of coordination. So honestly, I couldn't tell you what next target the legislature might go after, other than we have heard, Jim did mention, and Jennifer did too, I believe, that um, some of these poorly written provisions have already been brought to the legislature's attention in terms of trying to correct them. So, but big picture, I don't know what the legislature will have next on its sites. Jim or Jennifer, you want to add to any of that?
I did see one question that just popped up that I would address, which is if you institute a formal electronic voting, can owners still vote by open email? No. Once you institute formal e-voting procedures, then that whole email ballot thing goes away. That is only in the event that you do not already have electronic voting in place.
Which is that alone makes a strong case for getting electronic voting if you haven't already done it, so that you don't have this extra unclear burden.
Board members are required to take continuing education classes for their directorship. I'm not aware that they've been broken down by category. I believe the statute, and it differs between HOAs and condominiums, just provides our requirements. I don't think the division has broken them down by like legal update versus ethics or anything like that. I think it's just take your hours and you should be good. But that also might be a good question for somebody over at the division.
And there's a related question to what I was just saying, that should we not form some consortium to influence the legislature? I want to make clear, the committee I mentioned under the Florida Bar Community Association lawyers has made it adamantly clear that we are open to hearing what the legislature is doing. We're there to help. They just don't really interact with that committee very well. So there is a group of lawyers who would love to help the legislature. It's just the legislature seems to have its own path that it follows. And that's honestly why you see some of these glitches in these bills, because even if the legislature wanted to follow its path, they should still at least let the lawyers weigh in on how some of the terms need to be consistent, where there's vagaries, that are going to be problems. So the legislature does as the legislature does, unfortunately.
So uh, let's see here. Somebody has asked a question twice about term limits because the term limit law became effective 2018, which means we're now up on the 8 consecutive years. So condominium directors are going to start facing term limit elimination. The question is, if somebody was elected in November, their 8 year, I guess, their term limit would hit in the middle of this term, I think is probably the question that's being asked. Would they have to resign immediately or would they serve out their term? And I have no idea.
Well, I mean, if there is the caveat in the statute that if no one else is running,
Yeah.
you know, there's that. So if you're a small association where just no one wants to run for the board, you're that this 8 year limitation may not be an issue.
Yeah, I mean, so the statute, as I read it, talks about terms expiring at the annual meeting. So my impression would be that they probably serve until the annual meeting, the next election, assuming as it should be, your election is held at your annual meeting. So I would think their term serves through, but again, that's not something that I know has been answered in the courts. So that's just based on a plain reading of the statute. Term limits for condominium directors are 8 years. A condominium director cannot serve more than 8 consecutive years starting July 1st of 2018.
And these questions, by the way, for those of you who are wondering, these are not related to the new laws. These seem to be some issues that are just coming up that we're answering.
So we've been asked twice now if e-voting is required. So you're not required to work with a vendor like Get Quorum or Host, but if the owner, you are required to set up an email or accept email ballots.
And I also want to bookend today to say, but please recall that we are talking about condominiums today.
Yes.
None of this, for whatever reason, the legislature has imposed all of this for condominiums. If you are an HOA director, none of this crazy stuff applies to you. The video recording of meetings, the e-ballot, email ballot voting, it does not apply to you. This is condominiums.
All right, well, we're at 11:59, and I think, like I said, there's been some peripheral questions that we are happy to address and have tried to do so, but it seems the majority of the questions about the statutory provisions have been answered. So we thank you for your time, and we appreciate the opportunity to try to assist you in understanding what the legislature's done this year. And I hope everybody has a good afternoon.